Hi guys, welcome back to my YouTube channel. I know I've been gone for quite some time, but I think I'm just gonna post content when I've actually got stuff to share, so that every time you use your data or whatever the case is, then it's actually meaningful and that you look forward to hearing what I have to say, because you'll know that every time I post, it's actually worth hearing and it's important. I'm actually just in the car picking my daughter up from school. But I've been putting off this video for quite some time, and I thought if I don't do it now, I'll never get around to doing it. And I actually just want to speak about this case while it's still fresh and while, it still matters, because the ruling was handed down on Monday, so on the 30th of September. So I am a few days late, but I did share aspects of this case on my Twitter and Instagram pages, those who do follow me on those pages. I also shared it on Facebook, but it basically relates to the validity of customary marriages. The case, which was handed down by the Supreme Court of Appeal, which is the highest court in all non-constitutional matters, meaning it does have more authority than the High Court, but less than the Constitutional Court, handed down a ruling which basically unpacks what constitutes a valid customary marriage. And in the case of Mgubela versus Mkabi, I hope I got that first surname right. Please, I apologize in advance if I mispronounced it. But in that case, the Supreme Court of Appeal, just highlights what the three requirements of a customary marriage are. And that is that the parties must be over 18. The parties who are getting married must be over 18. That both parties must consent to the nature of the transaction, so both parties must know that what they're getting into is a marriage. And the union must be negotiated and celebrated in accordance with customary laws. And basically that is exactly what the Recognition of Customary Marriages Act states. I think the issue that people are battling with is that last line, obviously, the negotiated and celebrated in accordance with customary law, to a point where, the court will literally take everything, will take every single factor into consideration in deciding whether or not there has in fact been a marriage. In the specific case that I'm talking about, the deceased, who's the wife, passed away. Deceased passed away. Oh wow. So basically I'm gonna use it like this. The man and the woman were married under customary marriage, but when she died, her family then came to the guy saying that they don't recognize the customary marriage between them because she was never formally handed over. And according to her culture, she was Tsonga. According to her culture, a customary marriage is only formed once she's been handed over and the groom's side of the family. So the groom then said, no, we actually are married, because in as much as we didn't do the handover, no one stressed the importance of the handover when I first came to pay mahadi. He had paid 9,000 rand of the 12,000 rand mahadi. Gifts had been exchanged. There had in fact been a small celebration of the exchanging of gifts. In addition, the couple also got married at church. I don't know why they didn't end up registering the marriage. I have no clue why, but they ended up doing a white wedding at church, and both families were there. They were there in celebration of this union between the two. And the only thing that the parties didn't do was register their marriage at Home Affairs. They did attempt to register it with their traditional council, but on the day that they went to get it registered, the traditional councillor wasn't there, so it never happened. The family of the wife is also then complaining that when she died, she wanted nothing to do with this man, and apparently the man had been, cheating on her. Be that as it may, the husband then came forth and said, actually, when she got sick, you guys told me not to come to the hospital. And out of, fearing for my life, I also didn't come to her funeral when I learned that she had died, because, you guys had been threatening me. Well, the older brother of the deceased had been threatening the husband, saying, you're not welcome in this family. So out of fearing for his life, he didn't end up attending the funeral. Anyway, long story short, the court took a lot of factors into consideration. They took it that the parties had actually been staying together straight after the the mahadi process was taken care of, and before that they had been visiting each other at each other's houses quite a bit. And the family really, the family was trying to say they never knew this man until he came to pay mahadi. But the husband gave evidence which shows that this woman's daughter and the woman's brother recognized this man as a boyfriend because he had been introduced to the family before Ansa mahadi. Long story short, the court looked at those factors. They looked at the fact that the gifts had been exchanged. They looked at the white wedding as well, and the court definitely highlighted that in as much as a white wedding is not part of the customary law process, a lot of black people really do celebrate their marriage or their marriage union in the form of a white wedding. So based on that, the court couldn't deny that there was in fact a traditional marriage which was concluded between these two parties. The court then stressed the importance of customary law being flexible, and customary law shouldn't take away other rights which are enshrined in the Constitution, like the rights to dignity. And as long as the customary law principles do not conflict with constitutional principles and the Bill of Rights, then customary law can be developed to match our lifestyles today. One of the things that the court also said was, specifically with Tsongas, the tradition or the cultural practices, the customs seem to change depending on whereabout the Tsongas are situated. So one practice in, say, for example, Mpumalanga might not be the same as the practice that is done in Limpopo with the same tradition or with the same culture. So the court took the colorfulness and the ambiguities that exist into consideration. And the court also considered the fact that the husband is Swati and the wife was Tsonga, and already that leads to the possibility that the different customs won't be practiced in exactly the same manner. The court ended up ruling that in fact the husband is the rightful husband of the woman, and even though it wasn't a matter of him claiming a portion of her estate, it was a matter of asserting his rights, that he is in fact traditionally or married to this woman under customary marriage. Having said that, this case really just highlights the importance of people needing to conclude their antenuptial contracts before the lobola negotiations take place. Because it's starting to appear that, or rather, it appears that if you did not conclude an antenuptial contract before the lobola process happened, then you will be married in community of property. And what happens with that is, obviously, I've discussed it before in my previous videos. If you go check the different marriage regimes in my previous videos, you'll see when you're married in community of property, you do have a joint estate. Everything is cut in the middle, 50-50 between each spouse. And in a situation where she has died without a will, he would have stood to inherit intestate as the surviving spouse. So my view on why the family took to court was obviously they did not want this man to inherit from the deceased estate. Be that as it may, I strongly encourage everybody, like if you're going through the lobola process, before the uncles go knocking, before the uncles come to your home, ensure that you and your partner have spoken about concluding an antenuptial contract. Because it appears that if you conclude all your customary law aspects and then you wait a year until your wedding, until your wedding celebration, in between you are actually considered to be married in community of property, and more attorneys are going to start turning people at the door saying, listen, you now have to go through the high court process of converting your in community of property to out of community of property, and then you have to draft what is called a post-nuptial agreement, because that would have taken place after the customary marriage. So I really hope you guys learned Oh, is that sweat? I really hope that you guys learned from this video, and I really hope you're going to get your antenuptial contracts drafted. I do draft antenuptial contracts at a charge, and if you want to know more about antenuptial contracts, just drop your email in the description box below, and I'll send you a short explanatory note which will, you know, get you started. It explains the process, the different marriage regimes, and it also explains how much I charge for antenuptial contracts. Do get in touch at advice@sisterinlaw.co.za. That's ADVICE@sisterinlaw, one word, .co.za. Until next time, bye.